Namaste, Sakshi Manasakshi. I am Priya Goteti. Welcome to Sakshi TV special immigration show with Attorney Prashanthireddy Reddy from Law Offices of Prashanthi Reddy PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us@sakshi.com or call 866-725-7441. So before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need specific legal advice, please contact the attorney directly. Without any further delay, let's start our show. Hello Prashanthi, how are you and welcome to our show.
Thank you. I'm good. Thank you, Priya.
So Prashanthi, can you please provide information about your law offices, practice areas and your experience?
Well, my name is Prashanthi Reddy. I'm an immigration attorney. I have over 24 years of experience. My offices are located in Midtown Manhattan. You can reach me on the web www.reddyesq.com, and I do family as well as business immigration.
So Prashanthi, we have our first caller ready. Shiva. Hi Shiva.
Hi ma'am. Hi Reddy ma'am. Good evening.
Hi.
And hope all is well. And so I have a question. My name is Shiva. I'm here in Missouri. So I'm on H1B and I have my EB2 I-140 approved. I have a priority date of February 2012. Okay. So I could not downgrade my application because my current employer did not allow for that. So I'm waiting for my date to be current in EB2. So I have a daughter, so she's on H4 and she's aging out and her date of birth is September 12, 2002. So I hope that she will age out by September 12, 2023. So I'm planning to apply for her F1 visa as we got confirmation for a college here in our state. So I have a question, like let's say I applied for her F1 visa now and I know it would take around 9 months for that approval. So in the meantime, if my priority date, February 2012, if it becomes current and if I file I-485 along with my daughter, will it affect that F1 visa application? Meaning, will USCIS approve F1 petition still?
So
that's my question.
Right. So they will not approve the F1 if you have an immigrant petition pending, which is what will happen. But you may not need that F1 if you're filing for 485. So timing is crucial, right? So if it's taking 9 months for them, and it is taking 8 to 9 months for them to process that case, my suggestion is, since she's not aging out until 2023, so this is only 2021, maybe you want to wait for a year or so before you file her change of status to F1. So maybe you can file it next year. And then by then you will know, because October we might hear something about, again, dates moving forward, because every October we hear, right? Every October there's a significant change usually because that's the start of the fiscal year. So September, October, you'll hear something. After that, you can decide what you want to do. And as you know, EB2 dates are, well, moved quite a lot the last 2 months. So, I would suggest that you wait before you file for a change of status because you have time. I'm not saying wait until the last minute. File it about a year in advance. That should be sufficient. You don't need to file it 2 years in advance. Because if you do file it, yeah, go ahead.
Mm-hmm. Yeah, but my question is, like, in case if I applied for that and F1 got approved and my date was not current by that time, so after she moves to F1, if my date becomes current and when I file 485, can I include her still in I-485?
Yes. If that is the question, yeah, you had asked a slightly different question before. You said if it was pending, then what? But if it's already approved, if the F1 is already approved, then there is no problem in filing for adjustment of status from F1 to 485. The only thing is, once you file a 485, I suggest not to travel on that F1, of course. And
Correct. Yeah.
anything to do with USCIS, like any change of school or applying for EPT, OPT or anything like that, you cannot do. But as long as you don't do any
Okay.
of those things until that 485 EAD gets approved, you should be fine.
Okay. But I mean, the question is one quick question. So H4, when she's on H4, when F1 gets approved, but still H4, she has another 10 months to go. So once F1 gets approved, she needs to go to F1 immediately, or can we wait for
Yes.
another 10 months in
No.
H4?
No. You are filing for change of status, requesting F1. You cannot file more than 6 months in advance for anything, for any request. So you cannot wait. Once the F1 gets approved, it will be current. It will be changed to F1 status.
Oh, okay, automatically. Okay, got it.
Automatically, yeah. So you need to plan it accordingly.
Yeah, thank you so much calling, Shiva. We have another caller, Funny from Florida. Hi, Funny. Hello.
Hi, this is Mani. Thank you for taking my call.
You're
Yeah,
welcome,
please
Mani.
Hello.
question.
Yeah. Actually, I have a question. I am in EB2. My priority date is February 2013. So I got opportunity to downgrade my application in October. So my question here is, still I'm waiting for biometric EAD and AP and everything. Still it's not reached to me. So once we get a EAD, so I included my wife and child as well into my 480 application. So once we get a EAD, can my wife start using that EAD to work on that, or if I still maintaining my H1 and H4 for my wife?
So your wife can use the EAD, but she will not be on H4 anymore. She will be on 485 pending status. So whenever she travels, she will travel on advance parole. If she leaves the country, if she wants to change back to a H4, then she should leave the country and come back on a H4 on the H4 visa which she has stamped in her passport. So, but you can continue on a H1.
Okay.
I'm sorry?
Still, we have the valid H1 stamping, so we can travel and come back on the same visa, right?
So, are you talking about H4 or H1? We are discussing H4 right now for your wife.
Yeah, H4 only, yeah. Still, we are talking about only H4.
Yes, so the H4, once she uses the EAD, she will change to pending adjustment of status. Her status will be, it will not be on H4 status. Your status will continue to be on H1. So, if she wants to move back to H4 for whatever reason, if she wants to move back to H4, then what has to be done is she has to leave the country and come back on a H4. Show the H4 visa and come back on the H4.
But what I heard is in the other immigrants, what they're saying is still we can be in H1 and we can maintain the H4 status and can use the EAD, but not
if
AP.
you use.
Is that true?
Not if you use EAD. It is possible if you use advance parole. So there are two different things here. If you use advance parole to travel, it is possible after you come back to maintain your H4. So you have to, even the forums, whatever it is, it's confusing. So that's why you need to speak to an attorney. But if you use EAD, your status will be changed to that of an EAD, pending adjustment of status. That's what your status will be. It will not be on H4 anymore.
Okay, we have another caller, Rajiv from Chicago. Hi, Rajiv.
Hi,
Hello?
Prashanthi ma'am.
Hi, Rajiv.
So I have a question. So my wife is on H4 EAD, and we have a company, actually a small company for running a boutique. So we are about to go for our extension. So during the extension period, can she continue with the company, or she has to stop all her activities during the extension time?
Right, and that's kind of a gray area, but my suggestion to you is err on the side of caution and ask her not to be involved in managing or running that company during that H4EAD time. We all know that H4EAD is taking a long time, right? 8 months, 10 months, sometimes a year right now. So my suggestion is that she hand over management of the company and even maybe have a shareholder who manages the company while she's simply a passive investor owner, but doesn't manage the day-to-day activity because she cannot work. She has no work authorization without that EAD.
Okay, so I'm on H1, currently waiting for a green card. So like I-140 approved. So can I manage at that time, or I can't do that?
So if you do anything else other than what your H1B permits, you will become out of status. So unless you file a concurrent H1 for that company as well, which will be difficult if it's owned by your wife, they will not approve your H1 through that company.
Okay.
So yeah, it's not possible for you to do it either, since because your status
sure.
is on H1.
We have a caller, Sanjay. Hi, Sanjay. Hello.
Hello?
Yes,
Hello, can
Sanjay,
you hear
go
me?
ahead. Yes.
Yeah, hi. So my question is like, if you heard about Farmington University a couple of years back,
Right.
so
Yes.
like most of the students got deported and civis got terminated and all that thing happened. A lot of things got happened, right? So
Yes.
what happened if the same student tried to apply for new university and got civis, and then can he go to the stamping?
I don't see why not, because in that particular scenario, USCIS actually allowed, well, I wouldn't say that, because in some cases, University of Northern Virginia, etc., in other cases, they actually allowed people to move out of that university and change status. But even in this Farmington University cases, I know a lot of people who left. I mean, there were people who.
No, they're forcefully deported. You know that, right? They're forcefully deported into the
I
into
know
India.
that very well because I was very closely involved with the Farmington University cases. In fact, I was the one dealing with the consulate, helping the consulate deal with those cases. So we went to the detention centers. I know all about it. New York, New Jersey. We were really in charge of that whole process. So yeah, I'm intimately aware of that whole thing. So with reference to those cases, again, as I was, trying to give you a background, for in the Farmington University case, a lot of people left and were able to come back on fresh I-20s. So the fact that they were able to come back, that the consulate actually gave them a visa after the issuance of a new I-20 means that, their status is not in jeopardy. That's why they were able to come back. But again, there were a section of students that were deported or removed. I must say not deported. Deported is the wrong word. Removed from the country because those were the students that were unfortunately, visited by ICE, and they were given an NTA. But not everyone was visited by ICE because there were thousands of students. So some left before the NTA was issued. Some, so different things happen with different people. Some were arrested for criminal charges because, So my answer to the question is yes.
Another thing, no. So basically, do you think that ICE and USA is still investigating this case? Because I have my friend on H1B. Okay, so he got the H1B approved when he was in Farmington University. Okay, in 2018, a month before the issue came out, he got the H1, and just a couple of months back, he got the notice saying like we are intending to revoke your petition because at the time of approval you were in Farmington. Okay, so how to handle that case? Do you think so?
Right. So it is possible that when you file a change of status, they might say, I mean, unless you went to a different university, if you went to Farmington and you said you did your degree from there, obviously no one is going to believe it because there were no classes being held, right? So you have to basically, in response to that RFE, show what you did to make sure that you maintained your status once you came to know that Farmington University was, a bogus university. So you have to write an affidavit, basically saying what steps you took to ensure that you safeguarded your status and did not violate your F1 status. So you would need an attorney to do that, really.
I
Whoever it
already
might
reached
be.
almost like I already reached the Sheila Murthy and all that stuff. A lot of people.
Okay.
So but no one is helping on that one because they clearly
We
said in
can help
the.
you. Give us a call. You can give us a call tomorrow. We can help you. That's,
Okay, then we'll do that.
with
Then.
reference to how to respond to it. Nobody can guarantee you that you will get an approval, but, at least we know how to respond to it.
Thank you so much for calling us, and hope if you wanted, you can reach out to Prashanthi for special consultation. And viewers, today we'll be discussing on various hot topics on H1, L1, I-485 family and employment-based immigration. Prashanthi, this is a very most common question to many people. Like, what is the procedure to shift to a different company if a person is on his 8th or 9th year of H1B extension?
Right. So anything above 6 years, we know that the H1B limit is for 6 years, right? But how do you extend beyond 6 years? That, I guess, is the fundamental question. And there are many ways of doing that, getting your H1 beyond the 6 years. One is, of course, you leave the country, stay outside the country for a year, and then come back, you'll get a fresh 6 years on your H1. But when that happens, you have to know that you will be counted towards the cap, which means that you have to you can only file when the cap is open. That is in the month of March, you have to pre-register, and then when you get selected, that's when you can file. So that's a disadvantage of that, but that is one possibility. Second possibility is you can use your unused period on H1. So out of the last 6 years, for example, if you spent any time outside the country, you can recapture that time by filing a short extension, say for 6 months or 10 months or whatever time you spent outside the country during that 6 years. It could just be time spent on vacation, like every year if you took 3 weeks or 4 weeks off and went outside the country, that all that time can be recaptured. So that's a second way. The third way is that if you have 365 days have been pending since the start of your labor cert process, since the start of your green card process, whether you're in the labor stage or you're in the I-140 stage, whatever it might be. If 365 days are over, you can get an extension for further 1 year. Another way is if you have an approved I-140, and this is the best way, of course. If you have an approved I-140, you can get an extension for an additional 3 years at a time. So that's the best prospective. So whoever is filing for a green card, they're mostly filing so that they can get the I-140 approval, so that they can work beyond 6 years.
Yeah, we have another caller, Kumar from Dallas. Hi, Kumar.
Hi, thank you for
Hello?
taking my call. Can you hear me?
Yes, go ahead.
Hello. I have a quick question.
Yes, Kumar.
My current
Go ahead.
green card is waiting on the date to be current. My question is, we want to change the name of my spouse. So, if changing the name of spouse gonna have additional complications when we apply, when the date is current and we want to apply for I-485 for the green card, or it's not a big hassle if we change the name right now? Because after the marriage, we didn't get a chance to change the name. We want to change the name to the U.S. court here. And then also the additional question is, if we change the name in the U.S., in the U.S., can we apply to the Indian embassy to change the name in the Indian passport using the court approval from the U.S.?
Okay, so which question do you want to ask first? The 485 question I think I will take first, because it's a little complicated. Then after that, you're asking a separate question. But so let's talk about the 485 first. As long as you haven't, are you changing both the first name and the last name, or just the last name?
Oh, it's the complete name. Because
even the first name.
We want to change the complete first name along with my last name.
Oh wow.
she's gonna get the
Okay.
she wants to just keep the middle name of her original name, and she's gonna get my last name.
And you're changing the first name as well.
Yes, ma'am.
Okay. So you have to do the name change as per whatever the laws are in the US, advertise, etc., etc. And then once you do that, you'll get a document of a legal name change. Along with that document, you can apply for a fresh passport. And also, when at the time of filing the 485, you can show the new passport, and you can also show the name change document. And in the 485 application, you're required to mention all previous names used, and that will be there in the passport also. So make sure you fill out that column as well. So it's not a problem to change your name, before you file the 485.
It's not a problem in the 485, and also it's not a problem or the hassle to change the name, to use that court order to change the name in the Indian passport, right? In the apply for the
Yes, once
embassy in
you
Indian
get
embassy.
correct. Once you get a name change, then you have to follow the procedure for changing the name in the passport. You have to contact the Indian consulate for that.
Perfect, makes sense. Thank you so much.
You're welcome.
Thank you for calling us. We have another caller, Sai from Houston. Hello, Sai.
Yeah, hi.
Hello.
Thanks for giving opportunity to talk. Can you hear me?
Yes, go ahead.
Yeah. So actually, I'm on OPT. My H1B got picked up in this lottery. So currently, I am at Massachusetts location, but current client company is located at Dallas. So is it possible, like, to file two different locations in the neighbor, like LCA?
Yeah, so you can put two different locations, and that's a good question. So his question is, right now, perhaps he's working remotely because of COVID, but later on, maybe he'll have to actually work at his company location or the client side location. So how to go about that in the H1B petition? That's the question. So basically for that, you have to show two work locations on the LCA. You have to show your present work location as well as your the future work location. Simply because you don't want to be filing an amended petition again, 1 year down the road. You want to avoid filing any kind of petition if you can, because it just decreases your liability with USCIS. Every time you file, there's some liability when you file with USCIS. It can get denied, etc., etc. So your exposure to USCIS will be decreased if you file now itself in the LCA with two work locations. The only thing to keep in mind is they might send an RFE asking, or even before they send an RFE, when you're filing it, you might want to say what each location is. You might want to provide documentation showing that there will be work at each location. So that could be a client letter or a PO which mentions both locations. So there are no further questions as to what those locations are.
Okay.
Okay.
Thank you for
So,
calling
like,
us. So thank you for calling us, Sai. And if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@reddysq.com or call 212-354-1010 or visit www.reddysq.com. Yeah, we are having some more callers to attend. Sorry to interrupt, but yeah, we have other callers also to attend it. So Prashanthi, one more question. So if a person wanted to do a part-time work on H1B, can he do that with a different company?
Yeah, so I guess your question is, he's already on a full-time H1B and now he wants to file and he wants to work for another company. Maybe he has part-time weekend project that he wants to take up, on the side. So yes, absolutely he can do that. But in order to do that, he has to file again a H1 concurrently. So a concurrent H1, which is part-time. So remember, don't file a new H1 or a transfer, then you lose your previous H1. Make sure that the H1 is a concurrent H1. There's a separate column that you mark in the I-129 petition, and then do it for as many hours that you need to. So that's absolutely possible.
So we have another caller, Satya from Atlanta. Hi, Satya.
Hey, hi. Can you hear me?
Yes.
Yeah. Good evening, ma'am.
Please go
So
ahead.
this question is, yes, good evening, ma'am. This question is for my cousin who is in India. So she's a first-time H1B applicant. So she did went for H1B interview on March 23rd. So the company and she doesn't know that there is a President Proclamation 10052 in place. So the visa officer gave a 221G letter asking for supporting document for the exemption. So then, we waited, and instead of after April 1st, she started filling the new DS-160 because she wanted to reapply again after April 1st. Then she received an email from Administrative Office Embassy saying that, to process your visa further, we need you to come and drop your passport. So they said, you can come Monday to Friday, this timing. And she replied, yes, I can come tomorrow. Then they sent another email asking her to download 220G document sheet. So in that, there are two options. Option A is supporting document for 221G. Option B is, further processing of visa. So what option should she select, ma'am, if you can guide?
So I have to look at the document to give you correct information. I don't want to give you wrong information, but it seems like if there are two options and they're not asking for any additional documents, it looks like they want to make sure that she is willing to continue with the process and that she is not withdrawing it. So you would obviously then check that option because they have not asked for any additional documents, correct?
Correct. So they just only asked for passport drop off and the document sheet, the 221G document sheet.
Right. Then we want to continue processing this case and then submit that along with the passport. That should take care of it.
Okay. Yeah. Thank you so much, ma'am. Appreciate your time.
You're welcome.
Prashanthi, most people have this question: if a person is on a H1B and if he wanted to start a firm and along with a US citizen, can he do it?
Yeah. So the question is, if they want to, they basically want to be entrepreneurs, right? And unfortunately, they are on H1 for a long period of time because, especially for Indian nationals, the green cards are taking 10, 15 years or longer to get a green card. So he's stuck as being an employee for someone, even though, they might have a more entrepreneurial spirit. So in that situation, unfortunately, you cannot work for your own company. You cannot start your own company and be on a H1. The whole employer-employee relationship, even though it's not a thing anymore, I doubt they will approve a H1 for at least for working for your own company. So the only way out is, of course, you can invest. There's a difference between working and investing. So you can invest and be a passive shareholder or investor, like you invest in Microsoft or invest in any private venture. You can be a passive investor, but you cannot run the show. You cannot do the day-to-day activities of the company. So if you have another partner doing that, then yes, you can be a passive investor.
Viewers, we have a lot of callers today, so please limit your questions to one. And Prashanthi, we have another caller. Hi, Nanda. Nanda from Atlanta. Hi, Nanda.
Hi, ma'am. Good evening. Hello.
Yes, good evening, Nanda. Go ahead.
Hi, ma'am. I have a question. My H1 got approved in December. At the same time, my wife applied H4 and H480. After my H1 approved, she traveled to India and now she came back. So what could be happen, like applied H4 and H480, and with that she got a biometric and she completed the biometrics while she's coming from India, and again she got the biometrics. So what we need to do with this case?
So what do you mean coming from India? I didn't understand the question. So she's in the US. She applied for H4 and H480. She got biometrics. Yep. She went for the biometrics. What happened?
No, ma'am. So while she is in US, we applied the H4 and H480. Then, while it is in process, she went to India. When she went to India, she went for the biometrics and H480 stamped, and she came back to US. Now she got biometrics again from the USCIS.
Now, where did she go for H4? Where did she go for biometrics in India? You cannot take the biometrics in India, right? You have to take it in the US. She went for visa, you mean? She went for visa stamp,
yes.
correct? Is that what you said?
Yeah, visa stamping.
Okay.
Yes.
Okay, and then she came back to the US with the visa.
No, she came back, and now she got the biometrics appointment from the USCIS.
Okay.
She has to go it, or
so okay, I got it. So she basically doesn't need that H4 extension that you filed anymore, because she already has a H4 with a fresh I-94, right? When she came in.
No,
but you still might need that H4EAD, correct?
Yes, ma'am.
So if the biometrics is related to the H4EAD, then you have to go for biometrics. Otherwise, you will not get the EAD.
No, that is related to H4 extension, right? Not for the H4EAD biometrics. Generally,
If you know that for sure, then yes. I don't know that, what it's related to, unless you tell me. So if it's related to the H4 extension, then you don't have to go for the biometrics. If it's related to H4EAD, then you have to go for biometrics.
Okay.
So you can inform them, if you're not going, that you don't need to go because you've already, you're withdrawing that extension request.
No, if you withdraw,
they'll anyway deny it.
Yeah, if they withdraw the H4 extension, but what will happen to H4EAD? Since the I-94.
Well, then they will send a RFE. They'll send a request for further evidence saying that you have withdrawn the H4, so there is no basis to get your EAD. Then you can show them the I-94 saying that you are presently in H4 status and therefore the EAD should be granted. Unfortunately, there's no way of doing that. You can try writing a letter to them with the receipt and all that, but it may not reach your file. Usually the only time they pay attention to any correspondence is if you respond to an RFE that they sent.
Thank you for calling. Yeah, thank you for calling us. We have another caller, Krishna from California. Hi, Krishna.
Hi, ma'am. This is Krishna. Thanks for taking the call. I'm calling. I have a question for my friend. His wife is currently Indian citizen, but she is eligible to take citizenship of another country, Nepal. Okay. So, question is, she's currently in H4 now in US. What if she go back to Nepal to get Nepali national citizenship and Nepali passport? What happens to her H4? Can she still be able to stamp in a new, in the new passport, a Nepali passport, with the same petition?
So the stamp remains valid. The stamp remains valid, even if it is in an old passport. Her H4, as long as the I-94, yes.
She will have to renounce Indian citizenship, and then the passport has to be surrendered. So should she go and have a new visa interview schedule and get it stamped in Nepali passport?
So my understanding is that yes, the passport is surrendered, but it is given back to you, right? In a cancel form.
I'm not sure what happens.
Even after you surrender it, as far as I know, it's given back to you. Again, this is not US immigration. But even then, as to the extent of my knowledge goes, they give it back to you and they just say that it is cancelled. But the visa in there, they cannot cancel because that belongs to, that is issued by the Department of State, not by them. So it's the same. I mean, I would apply the same logic as if you have an old passport and you're extending it and you have a new passport. How the visa continues to be valid, I would think even when you change nationality, the visa is not affected. It continues to be valid until it is cancelled. So she should be able to travel if she has that passport and it is not, as you said, confiscated by the Indian consulate, then she should be able to travel with it. Otherwise, obviously, There is no visa, so
No,
she
her
has
visa.
to, there's no proof of a visa. So she has to go to the consulate and get a visa in Nepal.
Okay, her visa is anyway expired in Indian passports. Right now she's on petition, so there
Okay,
has to
so
be
then,
anyway
so
stamping.
then the question is moot. The question you're asking is moot. Anyway, she has to go and get a new stamping then, if it's already expired. Right?
Okay. Okay, thank you for calling us. And Prashanthi, this is like common question. Can we apply 2 H1B transfers at a time?
Well, you can. Nothing is stopping you from applying 2 H1 transfers, but you cannot be on 2 H1s at the same time unless they are filed as concurrent petitions, like we discussed earlier about the concurrent petition. So if you're filing 2 H1B petitions, then something called the last action rule applies, which pretty much means that whichever H1 was filed last, that will be your status. Of course, if you withdraw the H1, for example, you file company A first and then company B. Before it gets approved, if you withdraw the company B, then of course that will not be the H1 that is valid. It will be company A H1. But if both get approved, then the company B H1 will be the one that is valid.
Okay. So if a person is on L1 and he applied his H1 and his H1 got approved, so the L1 status, like he's no longer on L1 or it gets revoked, or what happens in that?
Yeah, so as of the date of the whatever time you put in the H1, if you said that the start date should be say October 1st, right? So as of October 1st, the L1 will no longer be valid. The person will be on H1. But before October 1st, maybe the approval will come in June, July. But so they'll continue to be in L1 status until October 1st, until the date that you've asked on your H1.
And how much time does one have to find another job when his H1B visa gets revoked by NS?
So once the H1 is, so whether it's revoked or not, once your job is terminated and once you are given notice, we have luckily a rule which is called the 60-day rule, based on which you can file for another transfer or a change of status within that 60 days of the date of your termination notice or the termination date with your employer. So you have 60 days to file within that time, and it is treated as a transfer, which could be another question as to when you can start working once that petition is filed. Do you have to wait until the approval, or can you file it while the petition is still pending? It is treated as a transfer, so as we know, in transfer cases, you can work as soon as the petition actually reaches USCIS, so you don't have to wait for the approval.
Okay. And this is regarding I-140. If an I-140 was approved like 180 days before, can an employer revoke it if the other person, if he joins in a different company? Can an employer revoke it?
Yes, they can revoke. They can do whatever they want. But the question is, what happens if they revoke it?
Okay.
Then what happens to his, can he use that I-140 after it is revoked? So yes, it can be used in certain circumstances. So for example, in order to file the 485, in that circumstances, it cannot be used because the employer no longer has a job for them. They've revoked the I-140. But it can be used in a situation where they need the I-140 to file. As I said, if the I-140 is approved, you can file a H1 beyond 6 years, right? In that situation, it can be used. So even the fact that it is revoked by the employer does not in any way affect that I-140. It can also be used to retain the priority date. So if it is revoked and tomorrow another employer obviously has to file the green card for you so that you can file a 485 ultimately, then the previous I-140 priority date can be used for the new I-140, even though it is revoked. So in those two situations, it can be reused, even though it's revoked.
So when is this I-140 no longer used for voting purpose?
The I-140 cannot be used for porting purpose only if I-140 is revoked by USCIS for fraud. That is the only situation in which I-140 then cannot be used for the 6-year, beyond 6 years H1 extension, and it cannot be used for porting either.
Prashanthi, like we were discussing on I-140. So we got to know that like when it happens a fraud, it cannot be like porting purpose, used for porting purpose. So like this is a very common question when I-140 is applied. So what are the next stages for a green card?
So once the I-140 is approved, then the next step is filing of the 485 or adjustment of status. So that's the next step, and that can only be done if your visa number is available. The visa number is basically a green card number, and there's a limited number of green cards every year. And we know there's a huge backlog for employment-based EB2 and EB3 green cards for Indian nationals. So every country has a certain number of green cards that are given. For India, those numbers are oversubscribed, meaning that there is more demand than supply. So there's a wait of 10-15 years, for to file the 485. So a lot of people go through the first two stages, which is the labor and I-140. But in order to file the 485, they have to wait for their green card number to become available.
Okay. So we have another caller, Vishal from Florida. Hi, Vishal.
Hey, can you hear me well?
Yes.
Hello?
Please go ahead.
Ma'am,
Yes,
I have a
Vishal, we can
question. Yeah, my H1 extension was done on a premium, so I got my approved. But for my wife, we have not got the H4 document, and she has also applied for the EAD. So meanwhile, for some emergency, we are traveling out of the country. So what will happen to her EAD application?
Yeah, so if you file an extension, they basically say that if it's not a change of status but it's an extension, then it will not affect that particular petition, whatever petition it might be. But if you're filing a change of status for, say, F2 to H4 or something like that, then that will get cancelled. And so because the EAD goes along with the H4, then that might get cancelled as well, or you might at least get a RFE on it. So we're more concerned about the EAD now, because H4, anyway, if she leaves, she'll come back on a fresh H4. So we don't care about the extension, we do care about the EAD. My suggestion is to, is it a change of status or an extension?
Extension. She's in H4.
So it should be
with
fine.
Having an EAD right now.
Right. The EAD should be fine, because they should process the EAD as long as you are eligible for EAD, which you are, because when you come back into the country, you'll be on a H4.
Right. But the people are saying that she has to go for a biometrics appointment first, and after getting the biometrics done, then only she will get the H4 EAD.
That is correct.
I don't see the connection here. But if she go out of the country, then she doesn't have to do biometrics, right?
Yeah, no, if you miss your biometrics, your EAD will get denied. It's simple as that. While she's outside the country, if you get biometrics and you're not able to go, then obviously your EAD is gone. So you have to come back and reapply. You have to meet all the criteria, right? If they're asking you, or if you get an RFE and you don't respond to the RFE on time, then of course, then also any application that you file will get denied, right?
Okay, so the best thing to do is wait till you get your H4 EAD approved and H4 application approved, and then leave the country. That's the best option.
That's up to you, right? But that's up to you. But if you do get biometrics and you're not here, then that's a problem.
Okay. Thank you for calling us. And Prashanthi, if a person is on a H1B visa and if he transfers to J1 visa, will he get more 6 years of H1B once the J1 gets expired?
So I guess the intent behind that question is basically to ask that, I had said earlier that you can get a fresh 6 years if you are not on a H1 for 1 year. Right. But I clearly mentioned that for that 1 year period, you have to be out of the country. You cannot be in the country. Mm-hmm. So just transferring your status to changing your status to a different status like a J or a F doesn't help you to get again again, getting the fresh 6 years. In order to get the fresh 6 years, you have to be outside the country, physically outside the country. So so the answer to your question is no, you will not get a fresh 6 years because they did not leave the country during that period. They simply filed a change of status.
Okay. And this is regarding the L1 visa's dependence, it is L2 visa. So how can one apply for a work permit for L2, and after getting a work permit, can they apply for a green card on L2?
Yeah, so if the L2 is pretty much like a H4. So if an L2 EAD, to answer that question, you can file for this I-765 and get an EAD or an L2, same as the H4 EAD. And the second question is whether they can file a green card. Of course they can file. If the principal applicant files a green card, then they can add them to the application, the 485, same as you would add a H4. And they would get the benefit along with all the family members would get the benefit along with the principal applicant. So yes, you can file a green card.
And this question is related because this is pandemic, like right now it's pandemic going on. So if an employer required to pay the required wage and the employee is afflicted with COVID, so consequently unable to work and is placed in isolation and quarantine during this treatment period, is he obliged to do that, employer, regarding the pay?
Right. So he can. So I guess the question is that if the person is suffering from COVID, is infected by COVID and cannot come to work, is the employer obligated to pay him? That is basically the question. So the answer to that is that if so we have to understand in what circumstances the employer is obligated to pay and what circumstances he is not obligated to pay. So if the employer says that, I don't have work for you right now, so I'm going to bench you, put you on the bench, and when I have work for you again, I am going to again pay you. And for that period, for the bench period, I'm not going to pay you. In that situation, since it's something the employer is doing, he's obligated to pay during that bench period, right? But as opposed to that, if the employee is requesting for leave or the employee is sick, whether it be COVID or any other sickness, or if the employee is, for example, pregnant and cannot come to work, whatever the reason might be, extended maternity leave, then the employer is not obligated to pay unless there's some labor laws in that state which say that, for example, certain amount of paid leave is mandated for certain circumstances. If there's no such law, then they don't have to pay. Or even if the employee is taking, say, a vacation and cannot, or due to family reasons, cannot come to work. So during that non-productive time, whether an employer has to pay or not depends on the circumstances. So with reference to COVID, since this is nothing to do with the employer, since the employee fell sick, he is not obligated to pay the employer during the COVID time. But you can argue that the quarantine requirement says he's not sick, he's asymptomatic. But the employer has some quarantine rules, obviously. The employer does, they don't want other people to get sick. So if that quarantine is being implemented by the employer, then that's not the employee's fault. So you can argue that, employee is ready to work, but employer, because of their rules, are not ready to bring them into work. So the employer has to pay during that period. So it really depends on the situation.
Okay. So we have another caller, Bala from New York. Hi, Bala.
Hi. Hi. Thanks for taking my call. Shall I ask my question?
Yes, please.
Shall I ask my question? Yeah. I have two questions. Let me ask you first. Yeah. First one is my priority date is January 15, 2011, EB2. Is it good time to downgrade or not? That is the first one. And the second one is my biometrics already done. I am waiting for my EAD. I'm expecting EAD in a couple of weeks. If I get the EAD, with that EAD, can I go to the India for a couple of months, like 2 months, and come back?
To answer your first question, really no one can guess as to how the priority dates will move and what will happen. So you have to use your best judgment. The only thing I can say to you is if you want to downgrade, make sure you don't file an amended petition, but file a new petition. So that way you can keep both priority date, both EB2 as well as EB3. So you'll have two I-140s and you can use whichever one is suited for you at that point, right? So you could do that and there's no harm in doing that, but as long as you don't file an amendment, because then you will lose your EB2 status and you will only be in EB3. So just make sure you file a new petition. Second is if you're filing a 480, your 485, what was your question about the EAD?
I already done with my biometrics. I am expecting EAD in a couple of weeks. Okay, so if I get the EAD,
so
with
travel,
the EAD, can I go to the India and spend
so you would travel. So you would travel with advance parole. EAD is work authorization. So you would travel with advance parole and you can come back on advance parole. But there is a controversy as to whether your status is now 485 status or it's H1 status. So if you want to maintain your H1 status even after, I would suggest filing an extension or an amendment just to be sure in order to maintain that H1 status as well. If you don't care about that and you just want to be on 485 status, that is possible by just re-entering on advance parole.
Thank you for calling us. So what is the golden immigration message that you wanted to give to the viewers?
I think I have given several messages today throughout so there is no one particular message that I have.
Okay. Yeah, thank you so much, Prashanthi, for answering all our questions, helping us understand and providing us with all the solutions. So, viewers, if you wanted to reach out with more questions and have a special consultation with Prashanthi, you can email at prashanthi@reddyesc.com or call 212-354-1010 or visit www.reddyesc.com. So, we'll be back next week with more interesting topics and on our next episodes. This is Priya Godeti signing off. You're watching Sakshi NRI. Thank you.